Good afternoon and welcome. My name is Kevin Igo, Managing Director of PFP, and I'm pleased to be presenting our webinar guest speaker today, Jesminara Rahman from Tax Resolute. The topic today is ADR, Alternative Dispute Resolution. It's something that's very much on the increase and becoming much more relevant in tax investigations work. And Jez, you were in right at the very start, weren't you, of the ADR?
Yes, when I was in HMRC, I was actually the ADR design lead. That was my official title. In fact, that's how we met as well, isn't it? One of our meetings when I was working with HMRC, and we was doing a nice little presentation for you on what ADR brings to HMRC and also to clients and customers.
Okay, so as usual, if anybody has any questions, please feel free to put them in the box in the usual way, and we'll get through as many as we can. Jez has particularly said she likes the thornier, trickier questions, so feel free to ask what you wish.
No problem. Okay, what is Alternative Dispute Resolution, or for short, ADR? HMRC very much follows CEDR, the CEDR definition, and CEDR, the Centre for Effective Disputes Resolution, defines mediation as a flexible process conducted confidentially in which a neutral person actively assists parties in working towards a negotiated agreement of a dispute or difference, and so on. In fact, HMRC, we did have a slight issue with neutral because it was HMRC facilitators doing it. So in a lot of our language, you will see in HMRC literature, we try and take out neutral. Neutral was taken out, and we use the words even-handed and objectively, but the word neutral is kind of taken out. The tribunal definitely welcomed ADR with open arms. And it is within the tribunal rules. It does say that the tribunal should seek, where appropriate, to bring to the attention of the parties the availability of any appropriate alternative procedure for the resolution of the dispute. So, as I said, tribunal loves ADR. As less cases get to hearing, and even the Ministry of Justice, they've acknowledged it as well as a very positive movement from HMRC, and HMRC has been acknowledged and applauded for the resources they have put into ADR, into developing ADR, as it's above and beyond from what they've seen in other organisations. Okay.
Okay.
Sure. Do you want me next? Okay, the history of HMRC ADR. Well, it involves third-party facilitators trained by HMRC, and they have compliance experience, so they would be caseworkers themselves. There were 2 pilot stages back in 2011 and 2012, and we always had the input of our external stakeholder representatives, so they could gauge, is HMRC being independent, objective, and so on? Is it according to the ADR principles? It started very small. There was only 6 trained facilitators in the beginning, but then in September 2013, around that period, 2012-13, I was involved. It then expanded, and we were given permission to expand with an additional 22 trained ADR facilitators, and it's even bigger now. It's much larger. I'm not quite sure how many at the moment, but it definitely has expanded. It's proved to be very popular. People tends to, clients and appellants, they prefer using ADR rather than going through the review, HMRC review route. They found definitely ADR has added value. Okay, ADR, when to use it? Well, when we have a position where it's unclear, you're not quite clear where you are with the case. It seems to be going round in circles. Or even when there's no dispute as such over the technical analysis, you agree with the principle, but not the actual quantum. So that's a grey area. When there can actually be disputes over the facts itself. So there's a disagreement, there's a grey area. Or even when there's strained relationships between HMRC and the taxpayer, when communications have broken down completely and you feel that a mediator is definitely needed. Also, when the taxpayer feels that information and documents have not been considered by HMRC. So when you feel that you have submitted information documents, and I know I've had quite a few ADR mediations myself where I know HMRC have not considered all the information and documents, and it has been put through during the ADR meeting, and it's found, then it is given proper weight. And I have found that to be quite invaluable. In each case, I mean, each case is actually judged on its merits. So you may feel there may be occasions where in one similar circumstances it has been accepted, but maybe another one it hasn't. And again, it depends on the facts of that case. There are some technical principles, red line policy issues, which HMRC will not apply ADR to, but even in some occasions, these have been tested. Because sometimes what HMRC thinks it's a no-go area is actually can be deemed as a grey area. There's some facts around it that can be discussed through ADR and agreed. Also, there's cases, if it's gone that far down the road where there's an appeal, there's a tribunal appeal that has been put in, and a statement of case has been issued on the case, then HMRC will, most often than not, will reject the application for ADR, because at this point, HMRC has committed all their resources and they don't see it as cost effective to go through the ADR process. But then again, it really does depend on the facts of that case. There may be some leeway and there may be some grey areas that can be explored and taken further. Let's go to the next slide. Okay, so ADR, what's in it for you? Well, in the first instance, both parties retain ownership of the decision. Whereas if you went down the tribunal route, the decision would be in the hands of the tribunal judge. It also enables parties to begin or resume negotiations when direct negotiations have stalled or are at an impasse. So you feel in the day-to-day casework or the communications is again just going round in circles. You're starting to play what I call tennis with correspondence. You issue one letter, they issue one letter back, and you're not getting anywhere with the tax position. Or it could just simply be that you feel like HMRC is just not listening to you. So you need to have someone in the middle just to facilitate the process so both sides feel like they're being given equal weight. I found when it's a difficult, entrenched position and you're dealing with, you know, a caseworker who's not perhaps being so cooperative, and I'm sure we've met caseworkers like that. A third party in the form of the mediator, or what we say ADR facilitator, changes the dynamics of a dispute and brings a fresh perspective. The other benefit to ADR is the completely confidential and without prejudice process. So everything that is communicated in that room, is whatever is said in within those four walls is kept within those four walls. And so you can test options that you may not be able to test outside ADR. So even if you feel you haven't reached an agreement and litigation is unavoidable, it can help both parties prepare the facts of the case. So even then, I think I've always felt that ADR adds value in clarifying your position and making it more cost effective, even if you go down the litigation route. Any information or documents that is shared in this process, within the ADR process, cannot be shared outside this process without the permission of both parties. So the only exception to this case is where if it's blatantly obvious that tax has been understated or there's been some act of tax fraud, then that's where the neutral position of the HMRC facilitator comes into question, because they can't be neutral. At the end of the day, those HMRC facilitators are HMRC employees. So if they see any acts of tax fraud taking place, they have to then stop the meeting and proceed and share that information.
So how are the ADR facilitators viewed amongst HMRC staff?
Actually, I think they're viewed in a very positive light from what I found so far within HMRC. ADR has definitely brought a very positive contribution within HMRC and has cut down on a lot of cases that otherwise would be entrenched or may go all the way to litigation, and where their chances of success would probably be not to that extent, probably not high. So in that respect, I think it's positively viewed. But then there are elements of, I suppose, internal competition maybe, because you've got the HMRC review route and you've got the ADR route. So those two, and I think ADR has definitely got the better publicity at the end compared to HMRC review route. The review option used to be called independent reviews, but then that term was kind of thrown out afterwards because that was brought into question. How can it be independent if you're an HMRC employee? So then they had to change the name to HMRC reviews. I definitely found ADR has added value compared to reviews. Reviews to me, I don't know what your experiences have been, but in my experience, it just seems to be a summary of what the caseworker has put across. So I've had very few where it's actually, being positive, but then I've had the review. There's so many cases where I've had a review take place and then had an ADR and settled it quite favourably in the client's favour.
Question from Narish: can ADR be used in COP9 case where no fraud has been proved?
Okay, actually, I do remember we were discussing this when we were implementing ADR, and we did have discussions with the Fraud Investigations Department, and they felt at that time it would not add value because there had to be the report facts. The facts have to be established. There's a risk assessment that takes place, and the COP9 investigators, I think at that time they felt it would not add value. So it's not normally accepted on if there's a COP9 involved. So the answer would be no, not really. It'd be one of the no-go areas, I think.
Okay. I mean, I think we have had a case. I've come across a case that was referred COP9 to ADR. Was it accepted? Yeah.
Then I would say probably on the facts of the case, then there can be exceptional circumstances when it has been accepted. But then I would say apply. Well, I was going to say, apply anyway, because you're not losing out. Right. And as I mentioned before, there's been red line policies where HMRC has deemed it this is a no-go area, but sometimes it's been tested and it's been seen, no, there are some areas that can be resolved through ADR, that can be discussed. So it is very much each case on its merits, and I don't think you lose out by applying. So, I mean, I definitely have done that. I've done that one, was it P35 late penalty case, and it was nearly £2 million. So normally they don't like to deal with cases of where it's involved with late penalties, because they think the HMRC thinks the litigation process, the tribunal process, is already in place to deal with issues like that, especially reasonable excuse cases. But in this case, because the amount was so large, you know, the quantum was so large, and there was a lot of circumstances and issues around this case, it was actually accepted into ADR. So again, I would say, even though they may say, this is why we don't, in HMRC at that time, and even now, you won't see a definitive list of what won't be rejected, because each case there may be something in there that you could apply ADR to. So you will never find a definitive case. And I was actually going to mention this later, later on, but then there's cases where you can have the statement of case has been issued, but on another case that has been rejected, but in a similar case where the statement of case has been issued in the same case, in a similar case, it's been accepted. So it might seem a bit bizarre to some, but again, it really does come down to the individual case.
Okay. Arthur raises the question, can ADR personnel be trusted? Trust being a pertinent factor in all HMRC dealings.
Considering I'm ex-ADR myself, I would say
no.
Yes. I would say you've had a lot of experience in ADR.
Yes.
So did you feel they couldn't be trusted?
No, ours has been, I wouldn't say universally positive, but yes, the vast majority have been quite positive.
I mean, I was also responsible for the recruitment of the ADR facilitators, and it's something we look into. It's not enough just to have like the technical skills, and sometimes it's not necessary to have in-depth technical skills, but it was important that they had the people skills to go with it in order to conduct the mediation. And that's why there's always been the external, stakeholders involved throughout, and there's always been that's why we're quite HMRC is very enthusiastic about the ADR feedback sheets as well, because it is something that ADR has always kept a careful eye on the objectivity of ADR and the independence of ADR facilitators. So far it's been overwhelmingly yes, they are quite independent, and I found in every ADR meeting I've had, the facilitators will really try their best to put across the client side. Definitely that position will be tested, and so I would say yes, otherwise ADR would not have been such a popular option. If we felt at any time ADR is not doing its job, it would not be successful.
Okay, you say it's popular. I mean, was it 1,400 a year, and yet there's 200 or 300 tax inquiries launched every year? Yes,
I mean, I would say, considering with the review process and the positive reviews we had, I mean, I admit I am biased because I am ex-ADR. I would say yes, so far it has been popular, but I do admit it has been really difficult to get the message out, and I don't know why that is, because ADR has done their best to spread the information, and it's just been really difficult to get them, to publicize ADR to all the accountants, that this is an option you have available. And this is one of the reasons why I'm doing this webinar today, to highlight. If you have a tax investigation and you're really stuck, you don't know where to go, then ADR is definitely one of the options you should consider. So I hope to make it more popular.
Okay, so a question from Gary. He has a current case where a client's been seriously ill and the caseworker seems to be ignoring this as a reason for extremely poor record keeping. Is that something that the ADR unit could help with?
If it's dealing with a grey area where you can't quantify the tax liability or the facts of the case, then yes, definitely.
Okay. Is ADR applicable for penalty disputes? Not late payment penalties, but one where you're in dispute over the behaviour?
Definitely, yes. And I have definitely used ADR for establishing the behaviours of a penalty.
Yeah. Katie asks, can ADR be used for any HMRC investigation?
Yes, in most cases, yes, as we've seen, because I thought not COP9, but it has been. I think the issue is if there's a grey area in a case that can be mediated, then yes, it can be used.
Okay.
And as I was we did mention the last bit, which was savings of time and cost. But ADR has been seen as cost effective, but I can discuss this later on. Okay, so why use ADR? Well, I've seen it definitely as a cost-effective method. From HMRC's perspective, they've said in comparison to 15 hours of time, HMRC time invested in ADR, to the tribunal time invested is to about 100 to 250 hours. So it's more cost effective to go down the ADR route. I see it as a last best opportunity in order to reach an agreement with HMRC, and it's definitely an option worth considering. And not just saving time in that respect, but if you are in a situation where you're just playing tennis correspondence, batting one to and fro back, I see it as a way as ADR is also a very safe option. You can have those discussions without prejudice, with confidentially, without it affecting your tax position. So you can explore those options that you couldn't do outside without it being recorded and put on file, which can actually prejudice your position because it goes towards behaviours as well. And I can't, HMRC has quantified their time as 15 hours, but is probably similar. I know it's similar for myself. I find it cost effective for customers as well, in that less time is actually goes towards an ADR than a tribunal litigation route. And even if the case has been ongoing, I've had a lot of cases that's come to me after 3-4 years. You know, someone else has tried to reach a settlement, but it hasn't, and it's been ongoing for 3-4 years, and it's come to me, and then I look at all the facts and I think, no, there's something here that can be mediated, go through ADR, and it's been settled. So the shortest time I've had a case that's come to me after 4 years is I've had it for 1 month and resolved it within that one meeting. And the client was extremely happy, actually, because after 4 years of agonizing, I mean, the client was actually suicidal at one point. We managed to reach a settlement pretty quickly. So not only is it cost effective, but I see it as a more faster way to reach a resolution. The other issue as well, why use ADR, is when you get to tribunal, I found the success rate kind of dips. It's up to between 14 to 25% between 2015 2018. So, I mean, you'd have to have a very, very strong, robust case when you get to litigation stage. So I find if there's, some grey areas, I do find ADR is the way to go in order to reach a resolution. It also allows for flexible discussions to take place that you could not in the normal compliance process, because, as I mentioned before, simply because it's without prejudice and it's confidential, and it won't be recorded officially on the file. So in addition, ADR does not affect your statutory review or appeal rights. So even if ADR, you feel you haven't reached a resolution on it, you can still go down the litigation route and go down the tribunal. But my aim has always been, as I'm sure yours has been, not to get to tribunal.
Yeah.
Okay, evaluation result. As someone said earlier on, there's been 1,400 applications. How can you call that popular? Again, it has been increasing. I think when I first started in 2012-13, there was about 400 applications. 2014, yes. So, I mean, to us, to me as an ex-ADR person, I see it as it has been increasing, and more resources have been put in. And, the more applications that come from, all of us out there, they'll definitely throw even more resources into it. So it's just a case of getting ADR known as an option for agents to use if they're stuck in a tax investigation case. So actually, when I left in 2014, it was the success rate was actually 94%. So for me, this is a bit of a dip at 80%. So over 80% of disputes are either fully or partially resolved. And I have had cases where you think, oh, we're not getting anywhere, but then you can come to an agreement. Okay, subject to providing this information, let's agree to this, or let's agree on this property and the other property subject to further documents, and so on. There are ways to frame an agreement, so at least you have progressed. It takes about 120 days for the ADR process, right from the start to the end. And again, as I said, they've assessed how long it takes of HMRC time to resolve a dispute, and they definitely found it was less hours compared to going to tribunal, which is an extremely intense experience. And we found it, and I have definitely found it to be more cost effective for the customers or clients.
Okay. More questions come in. Fatima, can ADR reach a compromise solution in difficult cases?
Definitely, yes, I would say so. It really depends on both parties, and you need that spirit of ADR has to be there. So the caseworker as a decision maker, and the client and yourself as a decision maker, both sides have to be willing to reach a compromise, and the mediator will try and initiate that. Definitely will endorse that spirit throughout.
So another question, how can we ensure that the decision maker is willing to compromise in advance of a meeting?
I actually discussed that later on. When I put before I even put an ADR application in, I always phone the caseworker up and say, I'm thinking of putting an ADR application in, because I think we're not really either, for whatever reason, we're not progressing in this case, and I feel having a face-to-face meeting would definitely progress the case, but only, and I have said these to caseworkers, only if the spirit's willing, I've said to them. So, I mean, otherwise there's no point us going to ADR if you're not willing to come to a resolution on this and you're willing to move. So I myself have that chat with the caseworker. And also the ADR facilitator has that chat with the caseworker. The caseworker, it's compulsory for them to attend and compulsory to take part, but you are correct. It's a case of, it may be compulsory, but the spirit has to be as well. They've got to be of a mind to reach a resolution. So a lot of that is having that discussion with the caseworker beforehand, or indeed getting there, having the ADR facilitator having that discussion with the caseworker beforehand.
Okay, to your last question, in a COP9 investigation, there have been a lot of penalties for late filing and payments. The client has mental health issues, and they've got 2 reports from psychiatrists confirming that. The issue is re-tax are systematic of his health issues. HMRC issued a lot of automatic penalties even after they knew of this situation. We've appealed, but they're stalling. Is this something that they could go to ADR on, separate to the COP9 investigation?
Normally, ADR does not get involved with late penalties, but there's a reason for that, because if it's a case of like the self-assessment penalties where it's £100 and you get a lot of those cases, and they're smaller cases, then it's to have a face-to-face meeting over maybe £100 penalty as part of the, which is an automatic process, is not deemed as a worthwhile use of ADR. But if you have there's been a certain amount of late penalties. I mean, for example, I mentioned the P35 case earlier on where it was almost 2 million. I'm not saying 2 million in your case, but there's a tax quantum there. It has caused a lot of distress, and you feel like communications definitely have broken down, then yes, apply for it. And as we said earlier, both of us, there's never, you don't lose anything by applying. Test the boundaries.
Do you need HMRC advance agreement to apply for an ADR review?
No, you don't.
Okay, what taxes can be considered?
Well, VAT, income tax, corporation tax, the main taxes definitely. I've just submitted an ADR appeal over VAT security notice. So it's not the actual VAT tax, but the deposit to be put down against VAT payments. Again, ADR you have to judge each case on its merits, because we even had it in the betting and gaming duty as well. So we definitely try to explore all areas in HMRC where ADR could add value and be applicable. And it's still an ongoing process, and it's still, we're still really, HMRC is still testing the boundaries. And I think us being the customers in this case, we should definitely test the boundaries to see how far we can go in getting HMRC to accept our ADR applications, especially if we can demonstrate that it will add value to the process, definitely. So I have actually had cases where, and I will talk about the process a bit later on, where it's within 30 days and they're not quite sure if they're going to accept ADR into the process. Have you had any like that? Or have all your cases just been accepted?
No, most of them have been accepted.
Yeah, I've had a couple that was on the boundaries, and then I had to talk really fast in order to get the case accepted into ADR. And this is when it goes to a board of CDR, ADR trained senior facilitators, and then they look at the application again. But they will definitely give it full consideration. Definitely absolutely nothing will be dismissed out of hand. They will look at it and think, can we apply to ADR? If the ADR facilitator themselves not sure they can accept it, then it will go to the board of the senior ADR facilitators, and they will also look at it. So everything will be fully considered.
Is the ADR process only suitable for SMEs and individuals?
No, large and complex as well. There is well, it's not large and complex anymore, it's got a different name. There is another there is another team at Westminster. They have an agreement when they train the ADR facilitators from these large and complex areas. They have to give their time, so they're taking out of their business those with the technical expertise to deal with it, because the ADR for large and complex issues, you know, they HMRC have to bring like several parties in, so it can get quite complicated. So you have like the technical experts in those areas, then you have the caseworker, then you have the manager, and then you have the actual ADR facilitators. Normally there's two, at least one will be present, who has experience and technical expertise in that area. So it may take a bit longer to get together, because to get a meeting arranged with several parties, depending on the technical issue, is not always straightforward. But once that meeting takes place, I mean, the ADR application is accepted and is arranged.
Okay. How much is the client expected to be involved?
Again, I was going to talk about this later. Okay. We're not even getting to the end of this webinar. The client has to be there on the day. So they are, because they are the decision maker, they have to be present. So it's very, very important you brief the client. I have had situations where the client has only been there for the beginning of the ADR, and then they've left halfway through, because most of the grey areas at that time it's been discussed, and they've given us they've given the agent the authority to carry on, but the agent but the client has to be present, and that's why it's very important to brief your client, have a meeting beforehand, go through the case and explain, you know, how you should go forward. I mean, one of the things I always say is, please don't guess an answer. Please don't estimate. If you don't know, you don't know. Don't try and fill in the gaps.
Can you apply for ADR after the time limit for appeal has expired?
Yeah, this has been another question that has come up in the past. If ADR will not accept, if an assessment has been issued, a tax assessment has been issued, then it has to be registered, the appeal has to be registered with tribunal. So it's one of the requirements, and they won't accept the ADR case into the process unless that appeal has been registered with HMRC. The reason for that is, if an appeal is not in place and it's expired, then at the end of the day, this is an HMRC ADR process. So it's not cost effective for HMRC to pursue it, because the appeal has expired and the tax assessment stands as it is. So in response to your question, I would say no.
Okay, thank you.
Okay. Okay, I like this bit. Inside the mind of HMRC, the litigation and settlement strategy is very, very important. In fact, I've even come across HMRC caseworkers who doesn't have good knowledge about what I will say for short, the LSS strategy.
I could introduce you to hundreds.
Yeah, but they have to abide by it. I mean, it's literally the underpin to HMRC's approach to tax disputes. And I've always gone back to this, that that's not what your litigation and settlement strategy states. So, I mean, I always put this across, and for those who you feel, I think someone mentioned earlier, how to get a caseworker, how do you know, they're positive towards the ADR process, that they are actually contributing to it. Well, question on of a similar mind. It's by using this that you point them to the litigation settlement strategy, that this is how a caseworker should be working according to these principles. So when I say inside the mind of HMRC, this is how you get to them. This is how they should be approaching the tax case, how they should be working their case. They should be supporting customers to get their tax right first time, to resolve those tax disputes which do arise in a way which establishes the right tax due at the least cost, and ADR endorses this, so it's definitely a good option. And the fact the law does allow settlement by agreement, and majority of the cases are fortunately settled this way. But the main thing I think is the last bit, that HMRC will be non-confrontational and will work collaboratively with customers wherever possible. And that's the key word, collaboratively. I'm not sure if you're all aware of this, but there's been a huge political movement with HMRC working together, working collaboratively. Any HMRC caseworker will know these words. It's something that has been pushed towards them for many years. They're supposed to be working collaboratively with you in order to get to the right tax position. So if they're being resistant, they're not communicating properly, the case is just not working, not going forward, it's just really quite hard just to deal with the caseworker. This is one of the approaches you can use by saying, well, we're supposed to be working collaboratively together on this case, and ADR is definitely an option which demonstrates HMRC and the customer working collaboratively in order to get to the right tax position. There are other factors as well in there, in that there's where you have grey areas as well, where you don't just simply have one answer, but you can explore a range of right answers. And that's directly lifted out of the LSS strategy, a range of right answers. So that's another fact or approach that you can use in your tax investigation cases. But I would definitely read the litigation settlement strategy. I think it's about 27, 30 pages or something like that. And it's something that should be underlying all caseworkers' approach to tax disputes, definitely. Okay, so the ADR process. I think some of this we've actually already touched upon by the questions that you have generously asked me. If assessments have been issued, the appeal has to be accepted by tribunal before applying to ADR. And this has actually been a change in the last 3 years or so, because before that you could apply for ADR at any stage. Do you remember that? There wasn't this limit put on it. You could apply at any stage, and I remember there was even one case that came into ADR even after it had gone to tribunal, and that was in order to quantify the tax at the end. But now, in the last few years, this law has come in. Probably they've come across a case where a lot of time has been spent through ADR, and then realised it was redundant because the appeal, had expired, and they couldn't go further. They wouldn't go to tribunal on this because no appeal had been put in place. So after that situation, they then implemented this rule, and it's not very obvious in the ADR literature. It's only when you make the application then it becomes apparent. They will ask, have you submitted an appeal to tribunal? And this only happens when there's when tax assessments have been issued. So in my cases, I'm normally quite happy if we've gone if we've entered ADR before the assessments have been issued, because then a lot of the legwork is cut down. Otherwise, you have to apply to the tribunal. If it's a VAT case, you have to then put in a hardship application and so on. So there's a lot more admin involved on that side. Whereas before the tax assessments have been issued, it's just a straight application online. So it's not difficult. The application, you can access it online. In fact, just Google it and put ADR HMRC application, and it will lead you to the page. It will lead you, there's a link in there, and it will take you to the application form, and you fill it in online. Normally, you will get an email acknowledgement straight away. It pings into your inbox. So it's quite an easy process. There's nothing complicated about it. The ADR application has to be put in by the client or customer or agent yourself, not HMRC. HMRC cannot lead on this. Only the customer can apply for ADR. HMRC can suggest it, and I think I've only had, surprisingly, two caseworkers ever suggest ADR, and I have to say I was absolutely gobsmacked when they did. I was so happy because they never do. Most of the time, 99% of the time, they do not mention ADR. I have to propose it to them. Then after you get the email acknowledgement, then it's processed. It's allocated to an ADR facilitator, and they will always be an ex-caseworker who's been trained in mediation and tribunal processes. So the ADR application is then accepted or rejected within 30 days. Within those 30 days, it's the ADR application goes to the ADR facilitator. You'll get a ring or phone call from the ADR facilitator, and she or he will discuss the application with you and also with HMRC. So if it's a grey area and they will say, we're not quite sure about accepting this ADR application, and that's when you can, pitch in your perspective and say, well, we think this is a grey area. We think our client has not been listened to. We think all the information documents has not been considered, and so on. And we feel that ADR process would allow us to present our case on a fair and reasonable basis. So then within the 30 days, then you will have, I think all of my ADR applications have been accepted. I've not had a single rejection. After 30 days is gone, they will phone or email you to ask you for a range of dates that you're available, and then they will ask you for an opening statement. And I always say, the opening, I'll go into that a bit later. After the other side will also submit an opening statement. You may get it before the meeting takes place. So you can look at HMRC's opening statement before, or sometimes you just get it on the day. So on the day, you'll read through your opening statement. The customer always goes first, and then HMRC will read their opening statement. And you will also receive an agenda, and you can have an input on the agenda. For ADR. One of the things I like to do, depending on the case, is go into the background, how the trade works, and what document information has been shared. I think there was one case where that was the shortest ADR I ever had, in 20 minutes. Because when I shared what documents information had been provided, it then became apparent the caseworker hadn't received it because he had gone to the appeal stage. So he went to the appeal caseworker, but for some reason it hadn't been forwarded to the caseworker. And so that was a very quick resolution, and the client was extremely happy that day as well. Depending on the technical issues, and so far I've not had any via phone. If it's a very simple issue, then they may deem it effective, more cost effective to have it via phone. If it's quite, it needs a face-to-face meeting, then the meeting will be arranged. And again, as someone asked earlier on, the client has to be present. Normally I leave one whole day open for the meeting. I don't put a time limit on it. I can't, because you can't say when you're going through a mediation, you can't predict when it's going to finish. But the aim of the day is to reach a resolution. So regardless of how long it takes you, the aim of the day is to have an exit agreement that both parties sign. So I know my longest meeting has been 9 hours. What's been your longest?
I know we've had them going on 7 or 8 hours.
Yeah. I think the longest I've ever had is 9 hours. I know there's been longer, but that's probably very much the exception. But normally about 7 to 8 hours, depending on how many issues has to be discussed. And in my application, if there's a penalty position, because with a tax assessment, there's always a penalty position, put in your application the whole tax and penalty issues. So everything should be considered globally on a holistic level. So you have a complete resolution for the day, on the day. You don't have bits and pieces that you have to deal with later on. And that way you are making effective use of your time.
Is the exit agreement a legally binding document for both sides?
Oh, right. I've had this one. Who asked that question? I've had issues with this, and I think we've had like a couple of tax cases on this. The exit agreement is not legally binding agreement. Okay, and I have also looked into this. The reason why it's not legally binding is because this whole ADR process is an informal process. It's an informal agreement. Both parties can't informally agree to it. But if you have a formal agreement, you would need the presence of lawyers. And this is how, because I have asked this question, which would really miss the whole point of ADR by formalizing that process. Otherwise, you'd be going down the litigation route. So that was the response that was given to me on this. Is it legally binding? I have had one case where, because the other issue is the agreement has to abide by the LSS principles. So what do I mean by that? Well, one of the principles in there says that you cannot reach an agreement that you would not agree at a tribunal level.
I think the cases that were lost were where the decision was wrong in law, wasn't it?
It was a Serpentine, Trust Limited. So because that actually went against a technical point, a legislative point, and would never have been agreed in a tribunal. And that's why that ADR agreement fell through, because it didn't actually abide by the LSS principle. They can't go against their legislation at the end of the day, or the technical principles. That's why it's very important that we look at the grey areas of maybe an issue, a technical issue. And yes, it's important to test those red line policies, because what HMRC may deem as a no-go area, there may be some areas that we can come to agreement, and there may be some flexibility in it.
Okay. If discovery assessments have been issued during a tax investigation and we've appealed against them, requesting for the tax to be reduced to nil, and HMRC have acknowledged this, do we still need to have the appeal accepted by tribunal before applying to ADR?
What was the last bit again? I kind of lost track.
Okay, so the tax investigation,
Yes.
discovery assessments have been made, they've appealed against them.
For the tax to be reduced to nil.
HMRC have acknowledged that. So do they still need the appeal to be accepted by tribunal?
So HMRC then has no, because HMRC has accepted the appeal. Because that would be HMRC accepting the appeal. So, but on the other hand, there is a process. Even though HMRC has accepted it, ADR will say the appeal still has to be registered with tribunal. But it won't be an issue because HMRC has already accepted the appeal informally. So they will not go against that. When it comes to late appeals, the issue is normally you put a late appeal in and the tribunal or judge will then ask HMRC, do you have any objection to it? In your case, HMRC won't have any objection to it because they've already agreed to the appeal, and so the late appeal will be accepted. So yes, a tribunal appeal definitely has to be put in, and then you can apply for ADR, but I think a lot of it would just more or less be administration. Okay, so the last one. Okay, how to get the best results, and I've got 3 minutes to go whiz through this. How to get the best results for your client. As I said before, discuss the option of ADR with the caseworker before applying. I mean, if you feel that the caseworker is unwilling and uncooperative, remind them of the LSS principles that they're supposed to be adhering to. Or if you have a case or communication has completely broken down and you just don't want to even hear the caseworker's voice, the ADR facilitator will then deal with it. Because it's compulsory, and the ADR facilitator will ensure that they attend and that they have to cooperate at the end of the day. The online ADR application, again, keep it simple. We don't need War and Peace. Just I've seen a lot of applications got everything thrown in it. You don't need to. Just keep it simple. Outline where the grey areas are. Or where you feel that documents information has not been considered, or you feel you're just not being listened to, or your client hasn't been listened to. Opening statement, again, keep it simple. The many times I've gone to an ADR meeting and HMRC has whipped out like 2-3 pages summary of the whole case. It's not necessary. I'll keep mine short. It's meant to be just what it says. An opening statement is to open the meeting. Keep it simple. You don't need to throw everything in it. Prepare your client before the ADR meeting. Definitely, it can be an intense day. Ask for breaks throughout the day for your client, especially when you feel maybe things are getting a bit heated. You might feel a bit frazzled. Just take time out. Don't be afraid to ask for breaks. If you think, oh, I need to consider this, or I need to discuss this with the client, we need to take a break. Ask for a break, no problem. That is something that you can keep control of, throughout the day. We'd like a break now. That's fine. The other thing is there's a weakness in the judgment of caseworkers in that they don't seem to consider oral information as information that is given weight in tribunal. And this is the ADR is a good way to put across that any oral information here in the future, if our client is put on the stand, this would be given weight and will be considered as oral evidence. Again, base your figures on a reasonable basis. As I mentioned before, HMRC cannot accept a less alternative than would be accepted at tribunal. Again, the LSS strategy comes into play. Don't be confrontational. That's the other thing. It's supposed to be the spirit of mediation and cooperation. Both sides, the aim is to reach a resolution on this. Use the mediator if you want to put a proposal in. That's what they're there for. Use them. I have done that in the past when I'm unsure about something and I want to question it. Then I say to the mediator, please can you just ask the other side this question? Because at the beginning, first 10 minutes throughout the day, then you are put into separate rooms and the mediator goes between the two parties. So you can use the mediators to put across information or test the boundaries or test certain options. Yes, don't just sit there and have a discussion throughout. get the media to to pull their weight throughout the whole process, because I definitely do. I have tested proposals through the media, what would be acceptable and not acceptable, and then come face to face. And that's how I think in this process you definitely can get the best results in this position for your client. And that draws us to an end.
Okay, thank you very much. Thank you all for listening in today. This is one of our regular webinars that we carry out. And thank you very much, Jez, for coming along today.
You're welcome.
We will be sending around a copy of the slides afterwards for those who want them. Indeed, for those who don't want them, we'll still send you around a copy of the slides. I'll also take this opportunity to recommend our UK Tax Investigations Conference. We're running in the ICAEW in London on the 11th of October. If anybody's interested in coming along to that, feel free to book online in the usual way. Meanwhile, thank you for listening, and I hope to speak to you again soon. Okay,
I'll definitely be at the next UK Tax Investigation Conference. So for those of you attending, I look forward to seeing you all.
Bye-bye.
Bye.